Texas is now the most restrictive state in the U.S. for limiting abortion access, all because of a new law that uses a different playbook to cut people off from those services. The law went into effect Wednesday after the Supreme Court denied hearing an emergency appeal. Here's what it means. Texas now bans abortions as soon as a so-called fetal heartbeat can be detected, which is usually around 6 weeks. Well, that's before a lot of people even know that they're pregnant. There is no exception in this law for rape or incest. Now, what really makes this law unique is the way it's enforced, okay? So the language allows any private individual, anybody, to sue anyone they perceive to, quote, aid and abet another person getting an abortion. Let's go a little deeper into this tonight to get some more perspective on this. Jessica Waters joining us. She is a dean at American University and a specialist in reproductive rights law and advocacy. So, Dean Waters, thanks so much for coming on with us. A ton to discuss about this here. I mean, this is such a wide-ranging topic. But I want to start here. First of all, it's plain that the Texas law is in direct violation to the precedent set up in Roe v. Wade. But the way it's written, can this law in Texas still be challenged on constitutional grounds?
It's a great question, and I think a really deliberate strategy on the part of the folks who were behind this law in the first place. So the way that the law is written is it bans abortion after 6 weeks of pregnancy. So, before most women even know that they're pregnant. But it also has what's called a private right of action as its enforcement mechanism. So instead of the state, who normally enforces laws, being charged with enforcing the law allows an individual person in the state of Texas to just sue any other person who either provides or helps someone to get an abortion. The Supreme Court said that because of the way that the law is structured, they weren't able to actually block the enforcement of the law and didn't actually rule on the merits of the constitutionality of the law. So really deliberate legal strategy that did not allow the law to be challenged in the ways that they normally would be.
Yeah, so you could call it ingenious on one side, you could call it devilish on the other side, depending on where you stand on this. It's essentially a legal loophole that they've written that has been able to circumvent the Supreme Court. We'll come back to the court in just a second, but I want to ask this first. Seeing what we've seen this week with the SCOTUS decision, are we likely to see other states now follow suit? If Texas can get away with it, why can't we, perhaps?
I think it's possible. So the part about the ban and a ban at a certain point in pregnancy, that's not new, right? We have seen states around the nation try varieties of that over the past decade or so. So not new at all. This enforcement mechanism is new, and we've already seen that some states have indicated, wow, that's interesting. Maybe we should try something like that. So I do think we could see copycat laws in other states.
When we talk about the legal mechanisms here, it's easy to get sort of bogged down in the weeds and sort of get lost from sort of the layperson perspective on this. Let's lay out for folks, just because the Supreme Court issued one decision on this week does not mean that this Texas law is possibly done being heard in front of the Supreme Court, correct?
That's correct. So right now, with the Supreme Court's decision not to block enforcement, the law itself and the challenges to it go back to the Texas courts. That does not mean at a later point the constitutionality of the law could not be ruled upon by the Supreme Court. Right. Importantly, though, the Supreme Court is hearing another case later this fall. So they are already poised to hear a challenge to a Mississippi law that bans abortion after 15 weeks of pregnancy. So the court will be taking up a similar issue already later this fall.
Right. In the meantime, for women in Texas after 6 weeks of pregnancy, I guess they're just out of luck at this point until the Supreme Court takes this up. I want to ask you about some of the next steps here for abortion providers, for women there in Texas. Do they have any additional legal recourse? Will we see opposition to this law from multiple angles?
I think we will see opposition. I think for abortion providers and women in Texas right now, the question of recourse is like, how can I actually provide medical services, or how can I secure medical services that I need? So right now, the option for most women who are post 6 weeks of pregnancy will be to travel to another state. Yeah. That is going to be their actual recourse to get necessary reproductive health care.
Sure. Texas, obviously a large state. A lot of women might not have the means to be able to do that. Listen, we appreciate your time. Dean Jessica Waters from American University. Thanks so much for coming on with us.
Thanks for having me.